So we are looking at chapter 9 for criminal law, and this is the evidence chapter. I've added some additional content items, the slides we'll be using, but what I wanted to show you to start out with was I added the California link to California's evidence code. So let me make this a little bigger for us. Kind of fun, in California, our code only lives officially online. We do not have an official printed version, which you could argue maybe was really forward thinking. So when you go to a law library and you pull books like the ones behind me, you're actually seeing like a publisher who's published the code, and that's very helpful. But it's kind of cool that you don't even need to do that. You don't need to go to a law library to actually see the evidence code of California. So I've got a link here, and you can actually, even from here, if we went back one, you can actually pull the penal code. So this is our California code detailing, criminal behavior, and as well as the relevant punishments. I can't think. What time is it? And just for fun, you guys are getting me excited. I always go to homicide statute. It's easy to remember. It's a 187. So I think you can see this. So crimes against the person. So there's homicide. So if you've ever wondered, like, what is the official definition of homicide in California or any crime? Here we go. Murder is the unlawful killing of a human being or a fetus with malice aforethought. This is not like an abortion. This would be like if you kill a pregnant woman, right? You'd be really facing 2 charges. Anyway, so they're telling you it doesn't apply for abortion. Okay, so, and then it's like, so that's your basic definition. Unlawful killing with malice, okay? And malice is the mental state. The killing is the physical action. So remember, one of like the way back foundation principles of criminal law is you have a mental state and an action. Mens rea, actus reus. They must converge at the same time to have criminal behavior, to have criminal liability, be guilty. So the action here, I hope you can all see, unlawful killing, the mental state, malice, okay? So there's the actus reus, there's the mens rea. So then you get into like, well, what is malice? What does that mean? Like, I know what killing someone means, but what does malice mean, right? Malice may be expressed or implied. It's expressed when there is manifested a deliberate intention to take away someone's life. It can happen when there's no provocation, so just like if you want to kill someone. Anyway, so then let me go down and show you, and then it goes over second degree. Oh, question, sorry. Is there a question? Or chat me, let me know. All kinds of different things. I just want to take you to the penalties. So here we go. So again, if you're like, well, how do they know what the charges are? How do they know if you get convicted what you face, right? Every person guilty shall be punished by death, in prison without parole, or 25 to life. So death would be the death penalty. Without parole, LWOP, life without the possibility of parole, LWOP, or 25 to life, okay? So there you go. And then here's the punishment for second degree, right? Let's see here, 25 to life. Oh no, that's a different one. That's if you kill a peace officer. Oops, uh-oh. People, what's happening? Any rate, let me go back. I wanted to go to the second degree. Anyway, I just passed it. It's okay. This is if second with a prior. Not worried about that right now. Any rate, so what's cool is when you go through this, you can actually see all of the different penalties, the different sentences that can be associated. Is there a comment? Let's see. Melina says, yesterday I had a case of a CL client. Is that a client? I'm not sure. Who hit a motorcycle and the victim died 2 years later. Yep, the person was charged for reckless homicide. Yeah, and that is, you're right. Things can change in an instant, and probably they weren't trying to kill that person. It was probably a or reckless, but reckless is a key word too. So when you talk about the intent for reckless, that is usually looking at that their action showed a reckless or wanton disregard for other life, that it's so dangerous, it's reckless. So it could have been going very high rate of speed. It could have been doing like the kind of drag racing type thing. Oh dear. Um, so yeah, reckless is another one of those specific terms where you're really looking for, um, someone's actions to show that they do not have care for life, even though maybe they didn't intend to kill someone. So that's kind of a lot of the cases about like the Fast and the Furious drag racing, they go drag racing on the road. So driving 120, like if that guy that, was on the car chase had gotten into um, a car, killed somebody, right? That would probably, very likely it could be charged as a reckless homicide. Let's see here. Oh, okay. So Cal's telling us, I don't know about that one. Um, yeah, so if you're saying you're killing people because you're possessed by the logo of the Uber, that may be a classic case of where we really have to examine if the person is mentally stable. Were they able to form mens rea? Like they did kill someone, but were they able to form the requisite or required mental state? Were they incapacitated? Are they going to claim insanity? So if you think you're possessed by an inanimate object, that is something that can come into play. Let's see here. And yeah, so for sure, if someone's, on drugs, that can be a big factor. Yes, I know. It's like so interesting. So, people are reminding of the Slender Man cases, which were so crazy. Was it like a juvenile, a young girl kind of killed some people because she was trying to do it for some kind of Slender Man, like inanimate cartoon figure that was kind of scary. So they've killed someone, but again, do they have the mental state? What was their mental state? And depending on the situation, I mean, there's a lot there. And it's not just they're insane. It's a very close look at different levels and things like that. So, but yeah, that was horrible. I was looking. So we're getting excited. Maybe we should have a whole homicide look at the murder statute, and because I don't think we've done that as a group. I don't think we did it before we left, where we talk about first and second and the lesser included of first and second, which would include the vols, the invols, and then maybe even the vehicular cases and like the penalties and how the mental states, like how that affects that. So maybe chat in if you guys think you'd want me to prepare a homicide, since we're not doing it, our big mock trial. We can do a few more things that we haven't done in a few years. So I could bring in a nice homicide because everyone loves to talk about homicide. So let me know, chat in if you guys think that would be interesting to go through the homicide statute. And I don't know if you do that in other criminal law classes in the program, where you actually look at like what's the main one, what's the lessers, what determines whether it's a first or a second or one of the other lessers. I don't know, maybe you guys do that already in some other class. And if so, tell me. Oh, Daniel's saying that would be cool. That would help a lot. Yeah, so we could do that and play with the homicide statute. So I just need to prepare some material, and that'd be fun because then I can give you like a cool assignment to play with. A fun, cool assignment. Okay. So, okay, let's see here. Ooh, everyone's saying it would be fun. Khaled wants to approach the bench. Yes, Khaled, you can you can chat or unmute yourself. You're killing me. Pretty good. Okay. I'm dying. So anyway, before we went down this rabbit hole, I just wanted to show you that, I put the link to the California evidence code, but at the same time, you can go to penal code if you want. So here's the California evidence code, because that may be kind of fun for you to go back later and look. But at any rate, so if you're ever wondering where do they come up with this stuff, well, it's right here. It's passed by the legislature. And so you can, if you ever want to go look at some of those things. So I just have built in some more links for us in this module to try to help. And let me go back. Okay, I'm going to share the screen again. just since we're not meeting together, I want to give you guys some fun things and some different content, because I know just sitting around reading your book, you know, that's one way to learn, and I appreciate that. But um, there's many ways to learn, right? So I want to make sure that we can kind of get all the styles. And you're killing me. Mark, I forgot. I did not look at the parody thing yet. I totes forgot. So you may have to post it again. Does the 1 year and 1 day apply to the 187 murder homicide? Ron, is that the rule, where the sort of rule where you have to survive a year and a day, or if you die a year and a day later? You may have to give me some clarification, but it can't, because I think it can be longer than that. I think like that other case, if someone, you know, if they get punched out and they're in a coma for 2 years and then they finally pass away from the injury, I think you can still be charged with the homicide. I think that's what you're referring to. Are you talking about how long it takes them to die? I suspect. Yeah, so Diane is correct. There is no statute of limitations on murder, on homicide. So it's one of the, I think the only crime with no statute of limitations. You start to hear talk of maybe doing the same thing with sex abuse and sex cases, that maybe those should be extended out. But homicide has no statute of limitations, meaning if you murdered someone 50 years ago and they find out about it, you know, they could still charge you, as opposed to like stealing your neighbor's, you know, lawn chair will have, you know, a fairly, you know, what, 2 years, 5, something like that, statute of limitations. But the year and a day rule, it might be more of a specific thing or a civil thing. Let's see here. I'm just trying to think. I think the real question is, how long does it take for someone to die? Okay, thank you.
Open it now. Really fast move. It's a quick page to open, and you get. How are you not excited?
The year and a day rule is a common law rule from old school criminal law, that if someone survived a year and a day after like the assault or the beating or the shooting, then they wouldn't be charged for the homicide. Common law. So you have two big breaks, and this isn't anywhere in our book, so we're totally going off book deep into the world of criminal stuff. You have common law jurisdictions, and then you have model penal code, MPC jurisdictions. Most states are either MPC, model penal code, and then of course they've adopted their own penal code, right? It's not the model language, but model penal code is like a group of legal thinkers and lawyers and practitioners that meet every couple years and come up with what the statutory language should be, and they write it and get together and, you know, work on it, and then basically individual states either just rewrite that into their code or adopt it. So common law jurisdictions would be like a very old school, like I don't think any state does a common law, but you know, maybe if you're thinking like from the 1700s or the 1800s, the development of these legal traditions. So all of our law developed from common law traditions and theory, but has been transformed with, you know, the code. So, but yeah, so that year and a day rule is like an old school thing that wouldn't apply anymore in California, but that's why you've heard of it. And that's why I'd heard of it. I'm like, I know I've heard of it. And I, you know, but at this point, anything's possible, right? I mean, who knows what, I feel like there was like that old Saturday Night Live skit where like people would ring the doorbell and it'd be like a land shark or something. I feel like that could happen to me. Like someone's going to ring the doorbell and a land shark is just going to come up behind me and then play baby shark, because that's my life. Any rate, so Ron, great question. Thanks for putting up with everything. I know. I was in other meetings and I'm just laughing. You guys have the, you know, you can mute your screen, but I feel like I, you know, I have to show my face. Is that the land shark, Mark? that land shark video. We may have to play it at the end of class for sure. Okay, but where were we? At this point, I don't even know. Let me go back. So for the love. Um, I'm just taking you guys through what else I have added to this page for you guys. So I've added the evidence code link because I know you're all going to super want to check that out. This is a website, so it's a law firm, this evidence website, but I thought they had some really nice information. So this is, you know, a law firm obviously trying to, you know, increase business for themselves. But I just thought this was nice. You know, they've got kind of a couple little pages here that take you through some different things, plus some of the big links to the evidentiary rules. So again, with some nice examples. So that's more for you guys to enjoy and go over, you know, just giving you a little more content. So you're not just stuck reading your book, you know, which I think your book has a lot of great information, but sometimes it's nice. And then to see it more specific to California. And then the last link I have is a YouTube video. So I won't be playing it because that doesn't ever really work that well for us. But this is from California Young Lawyers Association. So it's part of the state bar, and it's meant for like new attorneys that are, you know, beginning, you know, they've already finished law school, they're members of the bar, they're learning all that good stuff. And it's what, 10 minutes, and it's with a judge Beverly Bourne, and kind of a little evidence training, some information. So again, I went through and found what I thought were some cool resources for you guys to help you with chapter 9 information. And then I will be uploading a quiz, but I'll give you plenty of time. But at any rate, so you can read your book, but I thought that would be fun to add those in. So thoughts or questions? And then I am gonna prepare the homicide thing. Got the LSAT thing, okay. I'm just totally dying. Okay, so let's actually jump in then to like today's content, which I know is exciting. I just can't wait. And I may need, this is so hard to tell, but when I'm in this screen, I can't see the chats. So let's see here. I'm gonna make Ron, can you be the chat master? Is that okay? If not, like tell me, but I can't see the chat.
Yeah, I'll do it.
Okay, thanks. So yeah, if a chat comes in, just go ahead and let me know. Okay, so anyway, so these are based on the book slides, but I've already started to like change them a little bit for us. Pretty basic evidence. You know, broadly, evidence governs what comes into the trial. So sometimes I do like to think of the trial as like a classroom, you know, and I don't have to let every person into the classroom, right? And there could be people standing outside that I'm like, nope, you don't get to come in. But everything that we let come into that classroom is now something you can observe, you can think about, you can, oh, okay, you know, so evidence, it's really important to think of it as like a gatekeeping function, that the jury only gets to see the evidence that the judge lets in, right? So it's like they're sitting in our classroom and they only get to see the evidence that I let into the door. They don't get to see the evidence that I keep outside, you know, and there are very specific rules that govern the judge's choice, right? And how the judge makes that decision of what comes in or what stays out. So we talked last week in chapter 8 about some of the pretrial motions, and how one of the most important motions that happens is the evidentiary motions, sometimes known as in the Latin, motions in limine, motions to limit, right? To close the door. So these motions will happen before trial, but you can also have, you know, when we love watching all the great crime shows, the law shows, right? You know, you can have absolutely in the middle of a trial, someone standing up and yelling objection, right? Hearsay. So these arguments over whether or not a certain piece of evidence or a piece of testimony is appropriate could happen before trial in motions in limine and the evidentiary motions, but it could also happen during trial, right? Kind of on the spot. And so often these arguments, if they're before trial, the jury is not there. But if they happen during the trial, this is where you'll see, like Khaled said, approach the bench. Like, we want to come talk to the judge privately, still on the record, you know, they're still making a record, but the jury can't hear what we're saying. And if it gets more extreme, sometimes they'll even have the jury leave, right? The bailiff will take the jury back to the jury room, and that will give everyone in court on the record again, but not in front of the jury, the chance to have that discussion about whether this evidence should be allowed in or should be allowed to continue. Because like the psychological theory, and I think it makes sense, is that once you've like seen something, like you can't unsee it. The more kind of academic thing for that is you can't unring the bell. But I just think you guys all know that, like, you can't unsee something once you've seen it. Once you've heard a piece of evidence, it's going to be incredibly difficult, like, not to have that, consider it, not to have it just in the back of your brain. It's almost impossible. So this chapter 9 is laying out some of those rules, like legal rules for when the judge lets things in, when the judge keeps things out. And there's a lot of like balance, and there's also a lot of discretion. Some things it's just sort of up to the judge in their best judgment. So it's like a long introduction, but at any rate, so we have rules, right? We have state statutes, court rules that really guide. It's not just totally up to them. And these rules primarily come from two places, right? If you're in federal court, you have the federal rules of evidence. Makes sense. If you're in California state court, you have the California rules of evidence. And for the most part, the states are pretty closely follow the federal rules. But you can have slightly different, they don't have to be identical. And then every once in a while, right, these can kind of butt up against, buttress up against, Fifth Amendment, Sixth Amendment, some of those, really important constitutional provisions, but not all the time. So we'll obviously, I think for this, we'll probably be looking more at federal rules, but they're pretty identical. So questions so far? And I know we've got a couple people in here who are super, like Samantha did mock trial very successfully at Santa Ana High School. So some of you, if you've done mock trial, you've played with evidence rules a lot.
And Khaled has a question that can the defense submit new evidence during jury's deliberation?
No.
Great question. So once the jury deliberates, that is actually considered the closing of the evidence. So what happens is, right, and this is probably coming up in like chapter 10, 11, 12-ish. But so, each side presents their case in chief, that's the phrase. Prosecution presents their case in chief, defense presents their case in chief, and there's cross-examinations back and forth. There's opening statement, closing statement. Even before closing statements, the judge will ask, is there any additional evidence? Is there any more witness? And the prosecution would say, we rest our case. We close our case in chief, so we're done. And at that point, you cannot bring any new evidence. And then it goes to the defense and they start calling their witnesses. And again, at the end of that, what do? We rest our case. Yeah, you could have a rebuttal witness called, but it would be in either the prosecution case in chief or in the defense case in chief. Once the defense has rested and the prosecution would have already rested, then very officially the case goes to the jury. And you could not present any additional evidence once that has happened. It's done. What sometimes happens is a jury will have a question. This is like a very California procedure. Jurors can submit a question, if they're debating, they can ask for evidence to be read back to them. We don't remember what that one witness said. Can you read it back to us? So evidence that was already presented, they can, get a copy of the exhibit or have the transcript read back to them so they can hear, and listen again to what that witness said. But there would be no new evidence that would be presented once the jury has the case. I don't know if that answers the question for Khaled or if anyone else has questions. Miguchi? Okay, I'm gonna assume let's keep going. It's yes. So here's a little bit of like the philosophy, the theory, the theme behind the rules of evidence, right? So you two things, and they sometimes can compete. So you want to have evidence that is being admitted, right? So it favors the admissibility of evidence. It favors letting the evidence in, letting the jury consider it, because, right, the more evidence they can consider, probably the better decision they're going to make. And the other kind of, big wild card is that the trial judge does have broad discretion, is sort of the phrasing you hear there, broad discretion to determine what evidence comes in and out within those rules. So favoring admission, but with broad discretion. Oh, and look, I've just got it written down again. So again, they can, fashion the procedures they deem necessary. So you might have some judges that really like to do everything pretrial. And some of that gets a little more varied in civil. In criminal, it's pretty well set out. But yeah, the rules are to be liberally construed to allow evidence in, right? So you can't just go crazy, but that is, if there's a really close call, you should ask yourself, is there any way, the judge should be asking themselves, is there any way for me to let this evidence in, that satisfies, in some cases, some competing rules, but they really do want evidence to come in. And I'm sure, I don't know if anyone's chatting, if you watch any of those like 2020s or Datelines or Prime Times, all those true crime shows, what always happens? The person gets convicted or not convicted, and then the news people interview some of the jurors. And they always say to them, would it have helped you to know that 6 months earlier they killed their ex-wife, or that 2 years ago they did the exact same thing to somebody else? Would that have helped you to know? And the people are always like, well, yeah, if I'd known that, we would have found him guilty. So you kind of see that where there is evidence that is not allowed to come in. But the point is, the case is just about that one situation. And to bring in prior crimes and stuff, it doesn't mean it can't come in, but it's very close look. And there are times where it won't be allowed in. So sometimes you see juries saying that, well, if I had known that, I would have made a different decision. It's like, well, the point is, legally you were given the information you were given and expected to make the decision there. And it just sort of is what it is, because it's meant to favor in some ways the protection of the individual rights of the defendant. Questions? Chat master, we good?
No one chatted anything.
Okay. I'm just shouting into the void. It's all good.
I'm like outside in the working area, so it's like I'm watching customers and like trying to listen at the same time.
I'm sorry. Do you want someone else to be chat master?
No, that's fine. I'm looking through the slides on Canvas too.
Okay. I know we got people doing a lot of stuff here, so oops, I think I went to two. You guys, I cannot catch a break. I think it's Thursday and like society's breaking down. Like I was saying to my class yesterday, it's like the sun's out and I feel like all my little bugs are like waking up from their shell. You know what I mean? They're like starting to, get busy. Okay. So, I don't know why we just go to hearsay, but I guess we do. Fine. Let's just go to hearsay. The first rule that you've probably the first rule that you've probably heard about, if you've watched any show, is hearsay, right? Everybody knows hearsay and everyone's heard about it, I guess I should say. They may not totally know about it, but they've heard about it. So what is hearsay? I think my next slide, yeah, it's an out-of-court statement offered to prove the truth of the matter asserted, right? Is like the basic phrase you hear. So a statement, an oral or written assertion, and most often it would actually be someone sitting on the stand giving oral testimony, but it could be also through an affidavit. So one of the things some of you may know, because a lot of you are focused on future law enforcement, is a police report often cannot be admitted as evidence in a trial because a police report is considered hearsay. So very helpful, right? Very useful to the process. Mostly used by police officers, law enforcement, to review in their personal notes so that when they go to testify, they will have a clear recollection of what happened. But you couldn't just admit the police report. that often comes up against problems of hearsay. So it could be a written document, but it could also be the testimony you're giving under oath in the trial. The declarant, that's just a fancy way of saying the person who is speaking or the person who declared it in the written document, right? So a declarant, there's your fancy word for the day. The person who is giving the testimony, or the person who like wrote the statement down that now you're trying to admit that email or admit that document. And then basically, right, it's a statement other than made by the declarant while testifying, offered to prove the truth of the matter asserted. So let me give you some examples, and I think we'll do a little preview of hearsay, and then we'll probably come back to it even next week, because this is so down the weeds. Like, I saw you kill someone, okay, not hearsay. If I say, your mom told me you killed someone, oh, that's hearsay. Oh my gosh, we're gonna play a hearsay game next week. Oh, this will be fun. So at any rate, but the statement, I'm testifying, and then I say what someone else told me, that's classic hearsay. She told me you stole the money. Jessica told me you did that. Jose told me this. Somebody told me that. I mean, it is sort of extreme when you think of like how much that you know of information that's really just hearsay. Like, I don't know. No, no one's told me anything. I just heard somebody else say it on TV. You know what I mean? It's all hearsay, right? So someone told me that you said you murdered 5 people. That would be hearsay. So the point is, instead of me testifying to that, why don't you go call Jessica? Oh, why don't you call Tyrone? Oh my gosh, I just did that. Why don't you call Tyrone and have Tyrone say, right, what happened? Why are you having me tell people what Tyrone said? So whatever it might be. That's like such an old school, I don't know if that's Beyonce. I don't even know, but it's an old school song. It might be Beyonce. Any rate, so, if I'm like, well, Jessica told me this, Josue told me that, Michaela told me this, Melina told me that, Aaron told me this, Jennifer told me this, Patricia told me that. Well, why am I testifying? Why don't you call Patricia, Melina, Aaron, Diana, right? Bring all those people and call them as witnesses. And they will say, yeah, I saw them do it, or, blah, blah, blah. So you want to prevent people from testifying what they heard somebody else say. There's kind of multiple problems with it. And it gets way down the weeds. So some of you who might, be future lawyers, right? This gets really extreme. It's down the weeds. There's been a couple Supreme Court cases in the recent time, most notably Crawford, you gotta think, because it sometimes can involve the confrontations clause, right? If I'm saying, well, Jessica said you did it, but we can't have Jessica come testify, to some extent, some person is like accusing you that you have no chance to ever hear from. So there's kind of multiple layers of problems. And that reminds me, hey, if you forgot to get that case brief done, is it Gonzalez? I'll have to look, I forget the name now. But get that case brief done. I'll give you guys another day. So get that case brief done, because I think only about half of you had gotten it done. So mini case brief, get that one done. So obviously hearsay is inadmissible unless there's an exception. But P.S., spoiler alert, there's a lot of exceptions. I just put the book, it's like 206 to 207. And if we play some games, we might get into them. But like one of the famous exceptions, meaning you could testify this. So I could say, oh, actually, Josue did say you killed him. And they'd be like, objection, hearsay. And my lawyer would be like, there's an exception. What's the exception? Dying declaration. Oh. Josue was like bleeding out on the table, and he's like, Diana stabbed me, and then he dies. So the thought is, and some of these are very old school, like Ron, these probably, you were mentioning model penal code. Some of these things go back or to, the common law penal code and common law rules. Some of these things literally go back to like, the 1600s, the 1800s. Like, well, if you're dying, you're only going to want to speak the truth because it's your last words. So therefore it has like a little higher likelihood of being true, you know. So I feel like every movie has like a I'm dying, and someone's like, the gold is buried in my shoes, or she killed me, and then they die, kind of thing. So dying declarations are an exception to the hearsay rule. And the list is multiple pages long, so you can look at some of that, and we'll maybe go over a few, but you might have heard of that one. And I probably blew through any chat master or anybody want to jump in.
Melina said, so the police report is a hearsay before the officer took a statement for an individual for a second party. That's her question.
So often now, I don't want to like promise you that there's zero exceptions, but generally speaking, the police report, because of that exact reason, it's going to say the neighbor said she saw them fighting, and then the other neighbor said she heard crashes. And so it's going to have all these hearsay statements from other people. So if you just wanted to admit the police report into court, it has all this stuff that other people are saying, as opposed to the police officer taking the stand and saying, we got a call, I got there, this is what I observed, this is what I saw. And then, you know what, maybe you call the neighbor, and the neighbor says, yep, I saw this, I heard this is why I called the cops. But the document itself would, I don't want to say impossible, but it would have some problems with just admitting it, because all of those statements are exactly, to your point, hearsay, because it's going to have a lot of other witnesses. You use the police report to maybe decide what witnesses you want to call. You might use the police report to, did the police officers, do good procedure, right? Did they track everything? Does it, that kind of thing. But it would be better just to have that person come testify themselves, right? Rather than try to admit what they said, and it's also what the officer wrote down of what they said. Did the officer kind of summarize? Did they change it a little? All those kinds of things.
Then Khaled has a question of what is the difference between witness saying he saw the crime and he overheard the defendant threatening the victim?
Ooh, so a witness seeing someone like do something, that is an eyewitness, right? I actually saw, I actually heard. So sometimes in a really big word, and I can't chat you guys, but we call it a percipient witness. I perceived, right? I watched, I experienced, I heard. I am like a firsthand witness. I observed. Versus if I overhear like through the bathroom stall, like the defendant, like, I'm gonna kill you, like all those Hitchcock movies or something, like, I'm gonna kill you, I'm gonna do this, that. However, there is an exception to that. So that's where we would say, if I overhear like, someone like a defendant killing someone in a bathroom stall and saying, I'm killing you. I'm happy about it. I'm killing you right now. I hope that people are overhearing me kill you. And just if they're not certain, my name is Kristen, I'm killing you. Okay, So that is hearsay. Like if you call me to testify and I go, yep, I overheard the defendant in the bathroom saying, I'm killing you, and then I see blood and he clearly killed somebody. That is hearsay, but it's going to fit into one of the exceptions. And it's party opponent. And this is where it gets really, I feel like Samantha might know some of this really well too from her work in mock trial. So the defendant is considered the opposing party. And since they're the one who said it, that very well might come in because they have the chance to testify themselves. It could be a little different if they're not going to be allowed to testify, but probably it's going to come in. But the difference would be, Khaled, and to everyone, if then I told Josue, hey, Josue, I heard the defendant in a bathroom saying he was killing somebody, and then I saw blood and it looked like he killed him. And then instead of me, you want to ask Josue to testify to say that he heard me say that I heard, so sometimes that's known as like double hearsay. So we probably wouldn't allow Josue to testify that I heard the defendant say he killed people. I might be able to testify that I heard the defendant say it, but probably not Josue. If I've confused you, give me a thumbs up. Who's feeling confused? That might make sense. I don't know, maybe. Any other chats? Are we Gucci?
No more questions.
Okay, everyone's totally just like, this is crazy. I have to say, you guys, I'm so touched. I can see from the participants, once again, we literally almost have 100% attendance, which is incredible. And you guys should just give yourself like, you know, a pat on the back and feel really good about your efforts because this is not easy. And I know, as you guys can see, I myself have distractions and, you know, so I know that all of you are doing the same thing I am. And, you know, and maybe even in more challenging circumstances. So again, you guys, like, I'm just sending you a lot of love, good energy, positive vibes. I'm already feeling better than I was this morning when I was just like feeling a little low energy and kind of off. You know, it's getting kind of weird. Um, but wow, once again, I'm just so amazed. And I know, you know, some people can't even make it and they'll watch the recording, and that's great. So just cheers to you guys. I'm just so impressed. Like, this is incredible that, you know, you're all still showing up, and I'm trying to do my best to level up and like bring you guys, you know, what you need to get through this class. So anyway, so thanks guys. Okay. So yeah, there's so many exceptions to hearsay. You can literally like drive a truck through it. And you do get a lot of documents that will be allowed to come in. But police reports are kind of notorious for we don't want those to come in. But other things, you know, like sales reports, like Aaron, you know, if he's got sales records of all the ice cream purchases that day, that's the kind of record that really might be allowed to come in. But a police report, you know, is kind of like, you know, in a little different category. Okay. So I don't know if I love this slide, so this might be something that I change, but at any rate, when a judge makes a ruling on evidence, and I think you guys saw this when we went through the case last time, you know, we talk about, is it a harmless error or is it a substantial error? Is it an error that could actually overturn your case? Okay. And rulings on evidence, frankly, are probably some of the ones that are very likely to cause cases to be overruled, you know, overturned, have an appeal. But you have to show that the error was serious, you know, was substantial. So the error has to be brought to the attention of the judge, right? So the slide uses the word alert. So what does that mean? This is where it's important that the attorney makes the objection. If the attorney does not object, either in pretrial motions, right, motion in limine, or if they don't object during the trial, it's kind of a use or lose, right? If they don't make the objection, they are considered to have, right, there's that word, waived. Waive, and W-A-I-V-E, that's the legal term. You could also think of it as wave it bye-bye, the Elsa, let it go, right? So you let it go, which means that evidence is totally coming in. So even if like a court would look at it later and go, yeah, that was kind of bad, you shouldn't have let that in, that wasn't right. But if the attorneys did not raise the objection, then it is waived. It is let go, right? It's let go, just like Elsa. So if you don't raise the objection, then even if it's a really big mistake, the appeals court would be unlikely to give you any relief because you didn't bring it to the attention of the judge. You didn't alert, you didn't assert your right and your client's right. So really important to do that. And obviously when you make that assertion or that objection, you know, then things can, you know, proper corrective action. And it could be anything from just that evidence is out. It could be an instruction to the jury, right? That the judge gives some sort of special instruction, you know, not to consider that. Up to it, depending on how bad it is, right? It could even turn into a mistrial or something. We have to start over, or you know, they can't even do that. So I don't think California has this rule, but in some situations, like if you objected and then the judge is like, meh, overruled, I'm going to allow that evidence in, I'm going to allow that person to testify, then every time it comes up, some states would say you have to keep going, I renew my objection, I renew my, I know you ruled against me already, but I renew my objection, judge. Otherwise, again, you could be considered to have lost your objection. But I don't think that's California specifically. And it would get very cumbersome. Like you could imagine the judge saying, we will note that you have heavily objected to this. You've represented your client and I note that I disagreed and overruled you, but you don't need to keep saying you object every 2 seconds. We got it, you know. So you could see something like that. Let's see here. Any questions so far on this part?
Just a smiley face from Melina.
Okay. Yay, Melina. It's so much to be smiley about. I know, like, yay. Let's see here. Again, some of this this is where it's like, oh, these book slides get a little extreme. I guess we'll go back over here. Okay, so a lot of things would be handled before trial. Preliminary questions, you know, is this relevant? Does it make sense to come into this? Is there a privilege? Like, is there a Fifth Amendment privilege? Did this violate their Fifth Amendment privilege or their Sixth Amendment type of thing? You'll often hear those done before the trial would begin, outside before the jury's there, as well as confessions. I would expect that if you have a confession that's going to be introduced as evidence, and that would be something that in California would definitely be probed. Like, the judge would want to know, do you plan on introducing to the prosecution this confession that was obtained? And if the answer is yes, then you would expect a pretrial motion to look at that. Let's decide now, before we even get a jury, is this coming in? It could be the defense isn't challenging it. Maybe they say, nope, we're fine with it. And the judge would say, okay. Or it could be the defense is like, we seriously challenge this. We think it's improper, because you're talking all kinds of those constitutional issues at play, due process. So that would definitely be handled before trial. So that way, when they're in trial with the jury, you know, you're not wasting the jury's time with these really extensive evidentiary motions where they have to be in the conference room, right? We've already determined this, so we can go seamlessly through A, B, C, D. And that's part of it, is they really do want to be mindful of the jury's time and their requirements. You do sometimes have situations, and this is a bit of a deeper point, where the judge will allow something to be admitted, but only for one purpose, not for everything. And this can be difficult in real life, because of course, once you've seen something, you can't unsee it. But you could say, you know, this can only be admitted to show that the defendant, you know, was at the street corner that night. This is not admitted to show that they were buying drugs. You know, maybe it's not a defendant, it's a witness who saw the car accident or who saw the gang shooting, because they were at the street corner at 2:30 in the morning buying drugs, maybe more like 4:30 in the morning. They're at the corner of the street getting their their drugs at 4:30 in the morning, and they happen to see another crime take place. So you would hopefully maybe limit that out so that none of that's they're a witness, they're not on trial themselves, and there's Fifth Amendment issues. So, but if something like that came up, it could be, this is only admitted just so that to prove that they were there at that time and they saw it, not to bring in, you know, whether or not, but it's very difficult. And so sometimes this is the kind of thing you could see really limited, because it's hard. I mean, how can you unhear something? You know, you can't. I'm not worried about documents. I think we're going to pause here because, and we'll come back tomorrow at relevancy. So relevancy, or on next week, relevancy is the, you know, when you think about what can come into evidence, it has to be what is relevant, what pertains to the topic, what is, what's about the charges. You know, I don't need to hear evidence about like what you had for breakfast if that's not anything to do with the case. I don't need to hear evidence about, you know, what you were doing 10 years ago if it doesn't have anything to do with the case. And obviously it gets much deeper than that. But relevancy is maybe one of the main kind of blocks to evidence where, yeah, there's a lot of stuff like, you're right, you've been convicted of 10 crimes in the past, but that's not relevant to whether or not you did this crime last week. So relevancy is where we'll pick back up, and hopefully I'll have a little more custom made slides for you, because I don't always love these. But any questions on what we kind of talked about so far on all those? Okay, I'm gonna say it's probably no, but who knows? Okay, I'm gonna stop the share and then I can see. Oh,
Khaled asked if he could unmute himself so he could ask you a question.
Yeah, go ahead, Khaled.
Okay, this my question is about the case in chief. Let's say this hypothetical situation. These two guys and one lady, they're participating, invading a home to, to steal the jewelry. Um, the lady was like in the car, getting the car to be ready once they get out of with the jewelry. And the two guys killed, the housewife and her son. She has a daughter. She witnessed these two guys killing, her mom and her brother, but they were not aware that she was there. So, and they left, with the jewelry. Later, when they were tried, they all got like, this penalty. But and the girl was disappeared because she got a shock and she couldn't talk, and she like just like wandered out, out the house, and this guy, find her anyway. So the defense lawyer find the girl later before, uh, uh, the just as the jury was deliberating about the case, and he wants to bring her as a witness that his client, was not involved in killing the two, the mom and the brother, and but the case already went to deliberation, and can they still, introduce her as a witness to that particular lady? She was not involved in the killing,
Hmm.
because this is really crucial. She might, not get this sentence. She might get a little, a sentence like for life. Because she still participated in a crime.
So if I'm understanding your question, and I'm going to take this as a hypothetical, of course,
Yeah, yeah,
but
it is. Well, it was a movie anyway, but I
oh,
mean,
okay.
but I mean,
So
it's not an American movie, but
okay. So if it was in our justice system and things like that, but what is one of the things that can happen that you can have an appeal for, like assuming that they got convicted, right? And the case is done. If
yeah,
the case is done and they were convicted, you could have an appeal filed under our rules on the idea that there was evidence that they didn't have access to, and that, if the jury was able to hear from this additional witness, um, for whatever they, if they have some preliminary information that she's going to say it wasn't them, or she would testify it wasn't, whatever, like she would say it wasn't this one guy. The
yeah,
idea is that if the jury heard that evidence, they might have made a different rule. So then you get into, was the evidence restricted? Like, was the evidence presented to the judge and the judge said no? That could be an evidentiary question, but that could be overturned and then you'd have the case again. Or if it was something where they couldn't find the witness, or the witness was actively hiding, or maybe just no one knew, sometimes you have this, what we call like new evidence gets found, new information. So that can sometimes be a ground to appeal and to let the case, and really, it's not that they're just going to immediately be released, because they were still convicted. If it was, real and in our system, they were
yeah,
still convicted by a jury that considered everything appropriately, if that's the determination. So the appeal, then they would still be in jail, but they would get a new case, a new trial, with the chance to present that new information.
I
And then
see.
depending what would happen. Now, sometimes, like where you see this in happening in this country, a lot of times is kind of with like DNA evidence or new technology, like someone that was convicted of a rape case 25 years ago. Well, now they were able to run the DNA from the old rape kit. And they actually found out that it was someone else who was like a known rapist. In a lot of cases,
Uh,
it totally excludes the person that was convicted, and it totally, uh, um,
Pointing the direction of another person.
yeah, it totally says that somebody else did it. So then you can have an appeal filed saying there's like this new evidence that wasn't available, right? And this happens, I mean, not all the time, but this is pretty, we see this a lot happening. And that based on that, they should be allowed a new trial. Now, what really happens is the prosecutor, seeing that, oh gosh, like this clearly isn't a DNA match for the person that was convicted, instead of doing a new trial, they will simply say, we decline to file new charges and we're just going to, set you free, right? and then maybe there's going to be some additional proceedings. But if it was something where it's more of a closer call, they could say, no, actually, we're going to retry you, right? Based on, you've gotten this appeal and you get to be tried again. Okay, well, we still think you did it and we will still move forward. The other thing you can see is like if they win that appeal and are allowed to have a new trial, then you could also see the prosecution even entering another plea bargain to say, look, you've already served 10 years of a 25 to life sentence. So instead of going through this whole thing again, and which you can, like if you want to go through it again with your new witness, we'll go through it again, but we think we'd win. But what we are willing to do is maybe offer you a plea deal for 15 years to 25 with parole, or something, or serve 5 more years and we'll let you out, or I don't know. You could see different things like that. But yes, if there is a real witness that has real information that for some reason, and then you can get into it though, like if the defense was hiding them, different. I mean, it can go down the weeds, but that is a possibility. And probably the easiest thing to relate it to is maybe like new DNA evidence. So it's not exactly the same as a witness, but you can kind of see the similarities there.
Okay. Thank you.
So hopefully that helps.
Yes, it did.
I was like, otherwise I'm like, I don't know. It sounds like a real case, Khaled. I don't know. Let's see here. Anyone else have questions or thoughts? So what I want you guys to do is get that case brief finished if you didn't, which I think a lot of you did, but get it finished. And maybe look at some of the materials in chapter 9 that I've uploaded. I don't have an assignment for you guys, so I'm failing you. As teacher of the year, I don't have an assignment. So maybe the assignment is to view one of those other resources. Either look at that firm website that I put up, or look at the little 10-minute video from Judge Bourne, but check out one of those optional resources or go through the book a little bit. And then we'll come back into evidence next week, and I will have at least a quiz and some other assignments. I know, right? Good job, AA Run. Yeah, the assignment is just to survive the next 4 or 5 days, the weekend. But I really want you guys check out some of that content, because I know some people love reading the book. If you love reading the book, read the book. If not, watch that little video. It's kind of 10 minutes. What else are you doing? We're just waiting for the next Michael Jordan, The Last Dance episodes to drop. But yeah, so at any rate, any other questions or thoughts? Let's see. And if you came in late, go ahead and chat your name for attendance if you didn't already. And it's so good to see you guys. I think I spelled attendance wrong, but that's okay. Cheers to me. Let's see, Cecilia and Patricia, Jonah, Christina, Daniel, Abraham. I don't think I said hi to you guys before. Okay, Mark, I'm gonna copy this video. What is this? I'm gonna put it in there. I'm gonna take my live minute. Let me see. I'm gonna see what it is first, and then let's see what is this. Hopefully it's something marginally appropriate.
Hey, real quick.
Oh.
Before you get to the video
First I have to watch an
you're
ad.
about to watch, I'd like to give you 500.
Oh my gosh, it's a 1D parody. This is awesome. Okay, I'm gonna have to watch all of it, but that's funny. Okay, so you guys, Mark shared a funny video about a One Direction parody video. Who's the other? Are they getting back together? Is that the deal? Is anyone following former boy bands? Let's see here. Okay, Mark's sending me parodies. Awesome. Mark, you should just make a channel, and then you can upload them to your channel, and then we'll all do them. At any rate, it's so good to see you guys. So if you came a little late, let me go ahead and stop the recording. If you came late, you missed a lot of shenanigans. That's the bottom line.